Back, you're watching KTN News Desk. Now, the High Court is on the spot over the hefty cost judges have slapped on unsuccessful petitioners running into hundreds of millions of shillings. The Court of Appeal has expressed its dismay over the inordinately high amounts slapped on politicians and private citizens who were aggrieved with election results and had filed petitions. Judges Mohamed Warsame, Daniel Musinga and Otieno Odek on Friday termed the skyrocketing costs as going back to the old days when courts were notorious for imposing very high costs in election petitions. Now the judges questioned why the High Court reverted to the old trend of dismissing election cases and awarding large sums in costs, yet the judiciary had formulated guidelines on capping the costs. Now the Court of Appeal judges faulted their colleagues at the High Court for failing to borrow from the relatively fair costs of suits awarded to aggrieved parties following the 2013 elections. The judges made the remarks when they quashed the 10 million penalty slapped on former Cabinet Minister Martha Karua by the High Court sitting in Kerugoya after it dismissed her petition challenging the election of Kirinyaga Governor Anne Waiguru. Now the judges observed that the 10 million shilling cost was excessive, even if shared amongst Ms. Waiguru, RABC, and the returning officer, Seki Lempaka.
Shillings. The High Court.
So, Advocate Muthomi Thiankolu now joins me live by way of phone as we discuss these costly petitions and what are the likely consequences post-2022 after the elections with this kind of precedents being set by the High Court in the country. Thank you very much for speaking to us here on KTN News Desk, Muthomi Thiankolu. I would start by beginning with you being a lawyer. Why do you think most of these unsuccessful petitions are being slapped by such hefty fines?
It is just a misdirection on the part of the court. For me, the issue that arises is actually three issues. Number one, those orders directing litigants to pay huge costs are unconstitutional in at least three respects. Number two, when you read the relevant judgments, you find very serious contradictions. And number three, they also offend best practices from a global point of view. And if I may expound on the constitutional element, the Constitution provides at Article 48 for a fundamental right of access to justice. And there is a global consensus that if citizens have to enjoy these rights, then the cost of litigation should not be increased to a level that discourages people with genuine disputes from approaching the court. There is Article 50 of our Constitution, sub-Article 1, which says every citizen has a right to have any dispute that can be determined by the application of law, heard and determined by the court. If you impose very high costs, the effect in practical terms is to discourage people from filing election petitions, which is another way of saying you encourage those who participate in various illegalities and irregularities to continue perpetrating them in the safe knowledge that aggrieved persons will shy away from the court. On the issue of, there is another article about discrimination. You see, our court hears disputes of various types. Why is it that it is only people who file political disputes that are being slapped with these huge costs? It would appear to me clearly that would run afoul the provisions of Article 27 of our Constitution, which prohibits discrimination on all grounds, including political opinion, including social status or economic status, because the effect of these judgments is to say that only the rich, powerful, and mighty should be filing election petitions. Yet, our legal framework is every citizen, including the beggars on the streets, have a right to file an election petition. The problem of contradiction is you find we have various courts issuing very different orders. Sometimes you have an order for 1 million. I just finished a petition where the fees were capped at 1 million. You have another one where the fees are capped at 10 million. Another one at 6 million, and these contradictions, for me, bring disrepute to the whole system. Number two, while still on contradictions, the general rule is that the cause of any litigation follow the event. When you read these electoral disputes, you find a curious situation where the loser is awarded cost. And to be specific, we have had situations where an election has been nullified because the IEBC did not conduct that election in accordance with the law. Yes, you find the judge awards cost in the millions to the same IEBC who have been found guilty of not conducting the election in accordance with the Constitution. So that's a contradiction of sorts. The last point is about what is the global thinking. Closer home here in Tanzania, they ruled way back in the year 2001 in an election petition in a case called the Nabov as Attorney General that imposing huge costs or even the security for costs that we require in our laws was unconstitutional because it impedes the right of access to justice. So closer home, we have a jurisprudence that is now 17 years old saying that is the wrong approach. Just 3 months ago, the Supreme Court in the United Kingdom, faced with similar concerns, ruled that such enormous amounts of statutory payments and costs are an impediment to the right of access to justice. The curious thing is that in Kenya, with the possible exception of the judgment you are alluding to by Justice Odek and Wasame, anytime this issue has been brought to our courts, the courts have refused to entertain the question of access to justice, the question of discrimination, and all these things I'm telling you. But for me, I'm happy the Court of Appeal is finally accepting that if we maintain this trend, then we're actually breaching the Constitution.
All right, so thank you very much for speaking to us comprehensively, actually, on that idea of the costly petitions that have been slapped on unsuccessful petitions, especially election petitions that have been witnessed in the past weeks. That is lawyer Muthomi.